Yes, this is Mike Franklin. I'm the legal representative for the taxpayer in the case at hand, and I submitted the application for audiovisual request. And I wanted to review that with you so that you could make a proper determination, whatever that may be. I wanted to make you aware of how other judicial districts or hearing officers have handled such a situation. And oftentimes they will cite, I've heard that my training says that I'm not allowed to have these hearings recorded. That's not very specific. I've heard just plain denial. That doesn't work. I've heard reference to section RPTL 735, determination that precedent, that there to be no transcripts in SCAR hearings. I'll review that with you in detail, how 735 does not apply. I've also heard that Civil Rights Law 52 is determines that people can't record SCAR hearings, which is, we'll get into that as well. But let me just assure you that civil rights laws don't protect assessors nor hearing officers from being accountable to the public. And you know, since I'm here, I'll just talk about it briefly. Civil Rights Law 52 protects people's rights who are on mandatory subpoena and are required to testify, compulsory testimony, and so they have rights too. And so in certain circumstances, it would be appropriate to protect their rights and not allow them to be recorded by the media. However, in a SCAR hearing, their legal representative wants it recorded, the taxpayer wants it recorded, and the hearing officer nor the assessor have any expectation of privacy in a public hearing. The public has a right to record public officials in the course of their duties in public spaces. And a SCAR hearing is a public hearing, and it is a public space. And so, and then the third item that's commonly referenced is 131.1, the rules of the administrative judge. And the rules of administrative judge are kind of contradictory in that they say it's their policy to uphold the confidence that the public has in the judiciary, and to allow recording, except where limited by law. But and in some court cases, obviously, when there's rape victims and there's children, there are laws that protect those people. But there's nothing of that sort in an assessment hearing. And plus, the rules of the administrative judge are policies of the court for the court and court officials. They're not policies that for the public. They're policies for the court officials. And policies do not trump the First Amendment to the Constitution, freedom of press. And so, a hearing officer has discretion to limit recording, but they have to have a logical explanation sufficient to limit someone's First Amendment rights. And so it has to be documented, and it has to be very specific for the reasons for limiting it. So let me share the screen, and I'll show you section 735. Okay, give me 1 second. Screen. Start the broadcast. Okay. And here's section 735. Real property tax law. No transcript of testimony shall be made of a small claims assessment review hearing. The hearing officer's decision of a petition for small claims assessment review shall not constitute precedent for any purpose or proceeding involving the parties or any other person or persons, except as provided in section 739. 739 prohibits assessors from raising the assessment the year after a reduction is made by the court system, unless there's a building permit or a revaluation and other details. So 739 doesn't pertain to video recording And I can just show you that real quick, just so you know that it has nothing to do with video recording. Prohibition against change in assessment following decision of small claims proceeding. It's got nothing to do with video recording. So we'll go back to section 735. So often, a hearing officer will say that our training says that we can't record it. So let me show you the Small Claims Assessment Review Hearing Officer's Manual. Okay, this is page 11, or is it page 12? The page 12 of the Small Claims Assessment Review Hearing Officer. As you can see at the top, it says 2020 SCAR Manual Statewide Final. A hearing officer may take notes, but no recording devices of any kind are allowed by anyone, nor are court reporters allowed to transcribe the proceeding. And it references section 735. Well, did you see anywhere in section 735 where it says that there's to be no recording devices? It says nothing of the sort. So the Small Claims Assessment Review Hearing Officer's Manual it's training materials, but it's not the law. Section 735 is the law, and section 735 pertains to determination, not precedent. No transcripts are allowed because none are necessary, because it's based on determination, not precedent. So case law is not relevant. So a transcript is not necessary. It doesn't mean that the hearings can't be video recorded. And so let me help the particularly one judicial district indicated that otherwise. But let's define transcript. Trans as in translate, script as in scribe, as in writing. Transcript, translate to writing. And according to Black's Law Dictionary, in the context of court hearings, a transcript is done by a court reporter. So it's a translation to writing by a court reporter. A video is not a translation to writing, and I am not a court reporter. And so we're not asking to create materials for case law. We want it recorded to educate the public how assessment matters work, how Small Claims Assessment Review works, and also the intent is to have the assessor be accountable to the public, and to have the hearing officer be accountable to the public. Because if it's recorded, everybody behaves, with more integrity. But if it's clouded in secrecy, then people can say whatever they want, whether it's true or not. And so that's why it's important that these SCAR hearings be recorded. So if you, as the hearing officer, are going to deny me my right to record the SCAR hearing, you need to provide a written determination sufficient to overrule my First Amendment right to press. Again, this is Mike Franklin. I'm the legal representative for the taxpayer in this case. Thank you.